Hello and welcome to the Minimum Competence episode for Wednesday, June 18th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, court rulings halting Trump passport restrictions, tariffs challenged at the Supreme Court, blocked cuts to Pentagon-funded university research, and SCOTUS curtails rights for transgender minors. Let's remember, a talent is formed in stillness, a character in the world's torrent, and read today's legal news. On this day in legal history, June 18, 1992, the U.S. Supreme Court issued a landmark decision in Georgia v. McCollum, holding that criminal defendants cannot use peremptory challenges to exclude jurors on the basis of race. This decision extended the logic of Batson v. Kentucky, which barred prosecutors from racially discriminatory jury strikes, to defense attorneys, ensuring both sides are bound by the Equal Protection Clause. The case involved white defendants in Georgia who sought to remove black jurors, prompting the state to challenge the defense's strikes as racially biased. The court, in a 7-2 opinion written by Justice Blackmun, reasoned that racial discrimination in jury selection, regardless of the source, undermines public confidence in the justice system and the constitutional guarantee of a fair trial. It emphasized that the courtroom is not a private forum and that all participants, prosecutors, defense attorneys, and judges must adhere to constitutional principles. Importantly, the decision addressed the state action requirement, acknowledging that while defense attorneys are not state actors in the traditional sense, their participation in the jury selection process is conducted under judicial supervision and is thus attributable to the state. This broadened the scope of equal protection enforcement in criminal proceedings. The ruling was a major step toward eradicating racial bias in the judicial process, reinforcing that justice must not only be impartial, but also be perceived as such. By holding defense attorneys to the same standard as prosecutors, the court ensured that the integrity of jury selection is preserved across the board. The decision also highlighted the evolving understanding of the judiciary's role in preventing systemic discrimination, even in adversarial settings. Georgia v. McCollum remains a critical precedent in both constitutional law and criminal procedure, illustrating the court's commitment to fairness in one of the most fundamental aspects of the legal system, trial by jury. U.S. District Judge Julia Kobach expanded a prior injunction, blocking the Trump administration's passport policy that restricted transgender, non-binary, and intersex individuals from obtaining passports reflecting their gender identity. Kobach found that the State Department's revised policy, mandating passports list only biological sex at birth, likely violated the Fifth Amendment by discriminating on the basis of sex and reflecting irrational bias. Initially, the injunction applied only to 6 plaintiffs, but Kobach's ruling now grants class action status, halting enforcement of the policy nationwide. The policy stems from an executive order signed by Trump after returning to office in January of 2025, directing all federal agencies to recognize only 2 sexes and abandon the gender marker flexibility introduced under the Biden administration in 2022. The ruling marks a legal setback for the administration's efforts to reimpose binary sex classifications across federal documents. The ACLU, representing the plaintiffs, called it a critical win for transgender rights. The White House condemned the ruling as judicial overreach. The broader case remains ongoing. Educational toy company Learning Resources petitioned the U.S. Supreme Court to take up its challenge to President Donald Trump's tariffs before lower court appeals conclude. The company argues that Trump's use of the International Emergency Economic Powers Act, or IEEPA, to impose broad tariffs is unconstitutional and economically damaging, citing a May 29th district court ruling that found the tariffs illegal. That decision, however, is currently stayed pending appeal. Learning Resources CEO Rick Waldenberg warned that delaying Supreme Court review could cost American businesses up to $150 billion due to ongoing tariff-related costs. He described the tariffs as a hidden tax and accused the government of forcing importers to act as involuntary tax collectors. 2 federal courts have already ruled against Trump's interpretation of the IEEPA, a law historically used for targeted sanctions, not general trade policy. The administration defends the tariffs as a legal response to national emergencies like trade imbalances and drug trafficking, though critics say the justification is legally thin and economically harmful. While rare, the Supreme Court has expedited cases of national significance in the past, such as Biden's student loan forgiveness plan. A key appeals court hearing on Trump's tariff authority is scheduled for July 31st. A federal judge has also temporarily blocked the Trump administration from enforcing a new Department of Defense policy that would cap indirect cost reimbursements to universities at 15%. The move came in response to a lawsuit filed by 12 research institutions, including MIT and Johns Hopkins, as well as major academic associations. These groups argued that the cap violated existing federal regulations and congressional intent. The Department of Defense had framed the policy as a cost-saving measure, with Defense Secretary Pete Hegseth claiming it could save up to $900 million annually. However, universities rely on indirect cost reimbursements to fund infrastructure, staff, and equipment that support research across multiple projects, not just the ones directly funded. The ruling by Judge Brian Murphy, a Biden appointee, mirrors earlier judicial blocks of similar funding cuts proposed by the NIH and Department of Energy. A hearing is scheduled for July 2nd to determine whether a longer-term injunction should be issued. The case highlights growing legal resistance to the administration's broader push to reduce federal spending on scientific research. The U.S. Supreme Court upheld Tennessee's law banning puberty blockers and hormone therapy for transgender minors in a 6-3 decision that sets a national precedent and effectively greenlights similar restrictions in over 20 states. Writing for the majority, Chief Justice Roberts concluded that the law neither classifies based on sex nor targets transgender status, and thus only required rational basis review, not heightened constitutional scrutiny. The court accepted Tennessee's framing of the law as neutral and medically cautious, not discriminatory, citing European health policy shifts and purported uncertainty around gender-affirming care as justification. Critics, including the court's liberal bloc, argue the law does in fact discriminate based on sex and gender identity by banning medical treatment only when it aims to affirm a transgender identity. Justice Sotomayor, in dissent, emphasized that the law's language and application plainly hinges on a minor's, quote, sex as assigned at birth, drawing troubling parallels to older jurisprudence that permitted covert forms of discrimination under the guise of neutrality. The ruling marks a major rollback of legal protections for transgender youth, ignoring years of precedent that increasingly recognize transgender identity as a constitutionally protected status. By lowering the scrutiny threshold and deferring to legislative uncertainty, the court provided a roadmap for states to restrict gender-affirming care through general, non-explicitly discriminatory language. The majority's refusal to engage with medical consensus or the real-world impact on transgender youth reveals a troubling judicial posture, one that values legislative deference over individual rights, even when the stakes include physical and psychological harm to a vulnerable group. And on that grim note, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and minimumcompetence.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, one sees in the world what one carries in one's heart.